Hi there. This is Dan Daniels. I want to welcome you to this podcast on typical estate planning for married couples. A well-drawn estate plan will address any number of questions, but among the most important are those shown on the slide. Where do you want your assets to go? Who do you want to manage them? One of the hardest decisions you'll have to make in the planning process is who should be the trustee. And if you have minor children, who will take care of them? Who will be their guardian? If you have trusts under your plan, and it's highly likely that you will, what will the terms of those trusts be? How do we plan to minimize estate taxes? How do we plan to avoid probate? And what about incapacity? Minimizing estate taxes is probably the most complex of the things that we do in the planning process, so I'm going to talk about that first. The primary tax we worry about is the federal estate tax. This is a 40% tax that applies to everything you own when you die. There are two main exemptions from the tax. The first is the unlimited marital deduction. That's the ability each of us has to leave unlimited amounts to our spouse at death without the imposition of any federal estate tax. But the marital deduction merely defers tax, because anything I leave to my spouse will ultimately be taxed in her estate when she later dies. The only real forgiveness mechanism from the tax is the applicable exclusion amount. That's the ability each of us has to leave approximately $11 million to anybody in the world without the imposition of federal estate tax. I say approximately $11 million because that amount is indexed for inflation each year. Connecticut also has its own estate tax, which applies at a 12% rate. Connecticut does recognize an unlimited marital deduction, and Connecticut has an exemption from its tax that in 2019 is $3.6 million. The goal of good federal estate tax planning for a married couple is to ensure that they get to use two $11 million exclusion amounts instead of only one. And I think the best way to understand that is through a couple of hypotheticals. In hypothetical number one, we have husband, and he has an estate of exactly $22 million. And he has a simple will that says he leaves everything to his wife, and the wife has a simple will saying she leaves everything to the couple's children. So what's the tax result? Well, husband dies, he has $22 million, and it passes to his wife. There's no tax because of the unlimited marital deduction. But now what happens at wife's later death? She has that $22 million in her estate. She can shelter the first $11 million, her applicable exclusion amount, from the tax, but the remainder of her estate, the other $11 million, is taxed at 40%. So there's an over $4 million federal estate tax to pay before the children get their inheritance, leaving them with only roughly $18 million instead of $22 million. That could have been avoided. Hypothetical number two shows us how our married couple could have avoided that unnecessary $4 million federal estate tax. In this case, husband still has $22 million and he still dies first. But instead of leaving everything to his wife as he did in hypothetical number one, he breaks his estate up into two shares. Share number one is an amount equal to husband's applicable exclusion amount of $11 million. Instead of that passing to the wife, it passes to a trust called an estate tax sheltered trust. The wife is given a lot of rights over that trust, but just short of enough rights to be called the owner of it for tax purposes. The rest of the estate, which in this example happens to be another $11 million, passes outright to the wife. Let's stop there. What is the tax result? Husband has died, wife is still alive. Well, we know that the $11 million that passed outright to the wife isn't subject to a federal estate tax because of the unlimited marital deduction. What about the other $11 million that passes to the estate tax sheltered trust? Well, that's not subject to tax either because it's sheltered by husband's applicable exclusion amount. So there's zero federal estate tax to pay at husband's death, just like the simple plan. Where this more sophisticated plan changes things is when the wife later dies. Her estate can only be taxed on what she owns. Does she own the estate tax sheltered trust? No, not if it's been designed correctly. So that passes with zero federal estate tax to the children. What about the other $11 million that the wife inherited outright from her husband? That is included in her estate. She does own it, but it's not subject to tax because it's sheltered by the use of wife's $11 million applicable exclusion amount. In the previous slide, you heard me talk about the estate tax sheltered trust, and I mentioned that that trust gives the surviving spouse a lot of rights over the trust, but not enough rights to be called the owner of the trust for tax purposes. Well, what does that mean? Well, typically the estate tax sheltered trust can include the following terms without the surviving spouse being treated as the owner. First, it can provide that income and principal will be paid to the spouse for his or her maintenance in health, reasonable comfort, and support in his or her accustomed manner of living. Often the trust will also provide that the spouse is entitled to take 5% of the trust principal each year without regard to need, and that's in addition to what's available for their accustomed manner of living. The spouse is often given the power to appoint and remove trustees as well, and can even be the sole trustee. In the previous slide, you saw that the amount over and above the $11 million exemption passed outright to the surviving spouse. That needn't be the case. Some clients want to control what happens to the assets inherited by the spouse so that he or she cannot leave them to a new spouse at death. For those clients, the marital trust may be an appropriate vehicle. This is a trust for the benefit of the surviving spouse, but over which he or she does not have the power to give the money to a new spouse. When both spouses die, it's typical for the assets to pass into one or more trusts for descendants. For younger couples, a so-called family pot trust may be appropriate. This is a trust where the trustee has discretion to pay out income and principal among the family children for really any purpose and without regard to equality, sort of the way we assume most families would work while the children are young. For families with older children, we often provide that the trust assets at the death of the survivor pass into separate shares for each child, with each child having their own trust from which they may receive distributions for health, maintenance, and support. And often those trusts will say that at particular ages, the child may receive chunks of the money, a third at 30, a third at 35, all at 40, for example. Some clients want to protect the assets that their children inherit from the claims of a child's divorcing spouse or creditors. For those clients, the trust for descendants may be structured as so-called asset protection trusts. Traditionally, clients executed their estate plan through a will, a document that says, here's what happens to my assets at death. But wills are subject to the jurisdiction of the probate court. In effect, if you want to transfer assets under a will, your family or your executor has to get the permission of the probate court to do so. And that permission process can involve a lot of time, and because it involves a judge and court, it involves lawyers and legal fees. Some years ago, some clever lawyers came up with the idea of being able to transfer assets at death without the involvement of the probate court. The probate court really is only involved in the transmission of assets that were in your name at the time you died. The use of a revocable trust allows you to have no assets in your name at death, therefore no need for the probate court. How does it work? A revocable trust is a three-part document. Part 1 says, I now transfer all my assets into my revocable trust, and while I'm alive and competent, I retain the right to do virtually anything I want with these assets. I can put them in the trust, I can take them out. I can amend the trust, I can revoke the trust. Part 2 says, if I become incapacitated, as determined by the terms of the trust instrument, not by a court, then a second trustee comes in to manage the assets for me. Part 3 is the part that avoids probate at death, and that's the part of the trust that says, here's what happens to my assets when I die. So all these things that I've talked about before as being done under a will, like the estate tax sheltered trust and the trust for descendants, are instead done under this master trust agreement, which allows the transfer of assets without the involvement of the probate court. An extremely important footnote: the trust only works if you've got assets into it before you die. So after you sign a revocable trust, there's a lot of homework to do. changing the titles to your assets to the name of your revocable trust. And that's something that you'll talk about with your Wiggin attorney during the process of doing the estate planning. Functions of the revocable trust beyond avoiding probate are management of assets in event of incapacity, as I mentioned, and also privacy. A will technically is a public document. It gets filed in the probate court. That's not the case with a revocable trust, and for some clients that may be an important factor as well. One of the most important decisions in the estate planning process, and one of the most difficult, is going to be to decide who wears all the hats. Who will be the executor, who will be the trustee, who will be the guardian. The executor is someone who has a temporary job. It lasts about 18 months after your death, and that person essentially shepherds the estate through the settlement process. They hire lawyers and accountants to handle that. So it should be someone bright, responsible, and detail-oriented. Often it's your spouse to start with. It may be a child or children, but you needn't think that you have to appoint children as executors. It's not an honor to be appointed as executor. It's a heavy responsibility, so you should pick the person who's best for the job. Guardian is probably self-explanatory. This is the person who takes charge of minor children at the time of death. The trustee has a very difficult job in most cases because the trustee has to have 3 different qualities. They have to have the ability to invest the trust prudently, the ability to distribute it fairly, and the ability to administer it diligently. Those are 3 qualities that may not be present in any one individual. So you may find that you're appointing several trustees, one who may be good at the investment function, another who may know your children very well and therefore would be good at the distribution function, and you may have yet a 3rd trustee who's in charge of keeping books and records, who's particularly good at administration functions. This is a subject that you'll need to spend a lot of time on for most clients, and one on which your Wiggin attorney can provide some guidance as well. We've talked a lot about death and taxes up to now. Let's close out by talking about another pleasant subject, incapacity. Should you become incapacitated and have no planning in place, your family would have to go to court to have a court-appointed guardian handle your financial and personal affairs, and that's something most people will want to avoid, and it's relatively easy to avoid. For financial decisions, you'll want to have a power of attorney in place. Typically, you would name your spouse as attorney-in-fact, with some trusted individual as successor to your spouse. You'll also want to think about having an advance medical directive. This is a document that appoints someone to make your healthcare decisions should you become incapacitated. The healthcare directive also talks about end-of-life decision-making, expresses your wishes around the withholding or removal of extraordinary measures should you be in a terminal condition. Thanks for listening today. We look forward to helping you out with your estate plan. If you have questions, please don't hesitate to contact me. My contact information is shown on the slide. Thanks again.